contractor bonding requirements aim to protect consumers by providing financial security if a contractor fails to perform or complete work. The bond guarantees contractors have the financial resources to meet obligations and compensate consumers for damages. Washington Law RCW 18.2710 clearly states contractors must have a $4,000 bond. This amount was determined by the state legislature as sufficient to provide reasonable protection to consumers. The legislature intended to set a specific and reasonable bond amount that balances consumer protection and not creating an undue financial burden on contractors. A uniform bond requirement ensures fairness and consistency in the contracting industry. It prevents contractors from obtaining a competitive advantage by having insufficient bonding coverage. A higher bond amount may not necessarily provide more protection for consumers. It could make it more difficult for small contractors to obtain bonding, potentially reducing competition and driving up costs for consumers. The insurance agent may have made an error in providing a $6,000 bond. It is their responsibility to ensure you meet legal requirements. L&I is responsible for enforcing the state's contractor bonding requirements. They correctly require adjusting the bond to $4,000 as per the law. While it is understandable to be frustrated by apparent red tape, it is important to recognize these regulations are in place to protect consumers and maintain the integrity of the contracting industry. Streamlining the process could potentially create loopholes or reduce consumer protection. If an insurance agent provides a bond in the incorrect amount, the contractor should contact the insurance agent and request an adjustment to the bond to $4,000. Be patient and cooperative with L&I as they assist in meeting the legal requirement. If there are any concerns or questions, do not hesitate to contact L&I or seek legal advice. The specific amount is important for consistency and fairness across the industry. It ensures that all contractors meet a minimum standard of financial responsibility without imposing excessive burdens that could stifle competition and ultimately increase costs for consumers. The Washington State Department of Labor and Industries, L&I, is tasked with enforcing these regulations. Their insistence on a $4,000 bond is not arbitrary, but a direct implementation of state law aimed at maintaining a level playing field and protecting the public. To ensure compliance, firstly, carefully review the bond requirements outlined in RCW 18.2710. Secondly, communicate directly with L&I to clarify any uncertainties regarding bonding requirements. Thirdly, ensure the insurance agent is fully aware of the specific $4,000 bond requirement in Washington State. Fourthly, maintain detailed records of all communications and transactions related to the contractor bond. Fifthly, seek legal advice from an attorney familiar with Washington State contractor laws if any disputes or complex issues arise. These actions are vital for navigating the regulatory landscape, resolving discrepancies, and ensuring the business operates within the bounds of the law. The consequences of non-compliance can range from delays in licensing and project approvals to potential fines and legal actions. It's important to recognize that bonding requirements are not merely bureaucratic hurdles but are designed to protect consumers from potential harm caused by unscrupulous or financially unstable contractors. The legislative intent behind the $4,000 bond requirement reflects a balance between safeguarding consumer interests and fostering a competitive business environment. Adhering to these regulations is crucial for maintaining credibility, building trust with clients, and sustaining long-term success in the contracting industry. The specific amount serves as a baseline of financial responsibility, and that a higher amount may not always translate to better protection and could inadvertently create barriers for smaller businesses. Small contractors might struggle to afford higher bonds, potentially limiting competition and driving up prices for consumers. The $4,000 figure represents a compromise that allows smaller contractors to participate while still providing a safety net for consumers in case of substandard work or unfulfilled contractual obligations.